I will go ahead and call the second case, which is Meemic Insurance Company versus Angela Jones. This is also a 15-minute mayoral argument on the application. You each have 15 minutes. Mr. Schmidt, you may attempt to reserve some of that, but we ask you to try and keep track of that yourself, and you may proceed.
Good morning. May it please the court, Michael Schmidt appearing on behalf of the plaintiff appellant Meemic. It's our position that the Court of Appeals decision was clearly erroneous both factually and legally. First of all, on the factual basis, the Court of Appeals said that Meemic rescinded the policy as opposed to simply denying her claim. But the policy language says, if we pay the mortgagee for any loss and deny payment to you, it doesn't say simply deny payment. It says just deny. It's not conditioned. And the letter which Meemic used to deny the claim says on page 3, therefore, your claim on September 28, 2015 is denied. So the letter denied the claim. The policy says if you deny the claim, there's no condition or limitation on it. And in Rory, the Supreme Court said the judiciary is without authority to modify unambiguous contract terms. The Tarian case says the courts can't read words into a covenant that aren't there. The Cites case says courts do not rewrite the agreement of the parties. And in this case, this language is not conditioned. It's not limited. It doesn't exclude rescissions. It's just a deny the claim. In this case, Meemic denied the claim, and therefore it's comply with the policy and continue to subrogate. Now, the other problem is that although both Jones and the Court of Appeals agree that this policy has a standard mortgage clause, they both failed to recognize the effect of it. A standard mortgage clause is where you have a policy that says that a defense to the insured is not a defense to the mortgage holder. And in that case, and the cases say that it creates two different contracts, a contract between the insurance company and the insured, and a separate contract between the insurance company and the mortgage holder. And in this case, Meemic rescinded the policy between Meemic and Jones. The Court of Appeals rescinded both contracts. The letter by Meemic says, as a result, Meemic Insurance Company has decided to rescind and void the policy issued to you. Meemic did not rescind the policy that would apply to the mortgage holder. So the right to subrogation in this case doesn't have anything to do with the policy issued to Jones. It's well settled that anyone who pays off a mortgage debt is subrogated to the rights of the mortgagee. Meemic paid off the mortgage debt and therefore is subrogated to the rights of the mortgage holder against Jones. But in addition to that, the policy provides for the subrogation, and the provision for the subrogation is in the separate policy considered issued to the mortgage holder, and it's under rights and duties of mortgagee. And that policy,
let me interrupt you. Let me interrupt you and see what questions my colleagues have, and then if there are none, we can get back to your presentation. Okay, I'll start with Justice Viviano.
No questions. Thank you.
Justice Bernstein.
No questions. Thank you.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
No questions.
Justice Welch.
I actually do have a question, Mr. Schmidt. I'm hoping you can help me grapple with this a little bit. Obviously, it's no secret the fact pattern here is convoluted, and when we get into insurance and assignments, there's no question it's very complicated. In my research, most of the cases involving standard mortgage clauses involve the mortgagee, so in this case, City Mortgage, as a party to the case, usually because something between the insurer and the mortgagee hasn't gone right pursuant to the contractual agreement. So even if we assume the subrogation clause survives, in this case, you've directly sued Ms. Jones. And so I'm wondering, I think you agree with the premise that essentially your client steps into the shoes of City Mortgage and has the same rights. I think, do you agree with that basic premise as far as an assigner assignee?
Correct.
Okay, so if that's the case, what basis would City Mortgage have for a direct action against Ms. Jones?
Well, since we've paid off the debt, they don't have a relationship with her anymore. We paid off the debt. We paid off the mortgage. It's all paid off. They're done.
Right, but isn't the subrogation clause just between the insurance company and the mortgagee?
The subrogation clause is part of the contract, and the provisions of the contract say that defenses that we would have, the insurance company would have against the insured, don't apply to the mortgagee. So, for instance, if in this case the rescission for the misrepresentation application, that doesn't apply to the mortgagee. For instance, I had a case where the insured turned their house into a marijuana butane factory, and that was a violation of the increased hazard condition. That excluded coverage as to the insured, but not as to the mortgage holder. The mortgage holder in this case was fully paid off, $53,000. So there was no more debt. They're out of the picture. They're satisfied.
So would that be, I mean, a lot of these cases become foreclosure actions because that's something that obviously City Mortgage could have done if, they're not paid. So I guess, yeah, I'm still struggling about the direct cause of action for monetary damages. I'm wondering, is this really an equity case?
Well, I think it's both a legal breach of contract case and it's an equity case also. I think it's definitely an equity case because the insurance company becomes equity subrogated to the rights of City Mortgage against Jones because we paid the debt. And the Supreme Court case French versus Grand Reach, which is in my brief, it's 239 Mich 575. That's a 1927 case. It says that anytime anyone pays off a mortgage debt, you're automatically equity subrogated to the rights of the mortgage holder against the mortgagee. I'm sorry, against the mortgagor.
Okay, thank you.
Justice Zahra. You're muted.
Thank you. I'm just a little confused by this notion that you void the policy, rescind the policy as to the insured, but have a policy that remains in effect with the mortgagee. If that's the case, do you still need the policy language for your subrogation?
The policy language gives us the right to subrogate. So we need that's our separate policy with the bank. However, we're also equity subrogated because we paid the mortgage debt. That's under, like I said, that Supreme Court case French versus Grand Reach. There's numerous other cases. Whenever you pay a mortgage debt, you're automatically substituted to the rights of the mortgagee against the mortgagor.
So is your claim really one of equitable subrogation? Is that what you presented below?
Yeah, it's a combination of both equitable subrogation and legal subrogation because it's legally provided by the terms of the contract, where it says if we pay the mortgagee for any loss and deny payment to you, we will be subrogated to the extent of our payment. That's the contract. And then equitably, and I referred to the insurance case which you authored. We also fit within that.
Okay, thank you.
Mr. Schmidt, you have some time left. You may reserve it or continue at this point.
I'd like to just continue it. So as far as supporting authority, Jones did not cite any cases to support their position, and neither did the Court of Appeals, but there's been plenty of cases directly on point which fully support our position that if we rescind the policy, the insurance company still has the right to subrogate against the insured. And the leading case is that Citizens State Bank case, 1936 case. Same facts as this case, the insured misrepresented the mortgage indebtedness to the insurer. Instead of saying they were living in a house, they misrepresented what the mortgage debt was. And the Supreme Court said that would be a material misrepresentation that would void the policy. And then the Supreme Court said the mortgagee was entitled to recover under the policy under their separate contract, but the trial court erred in that case by denying the right of subrogation of the insurance company. And that's exactly what happened here. In this case, the Court of Appeals said you rescinded the contract, therefore you can't subrogate. Well, in that case, on the exact situation, the court said no, you have the right to subrogate. And I cited 8 cases from different states which have the exact same scenario as this, where the insurance policy was voided or rescinded for a misrepresentation of the application. And every one of those cases, they said that the insurance company could still subrogate against the insured. And one of the cases, the Peer case, had the exact same language as our case, where it says, if we deny payment to you. And now that leads into this equitable argument. So we have the contract argument from what I read to Justice Zahra as to what the contract says. Also, we have the equitable argument, because as this court ruled in Bazzi was the case where there's a misrep in an auto policy. And the court said that there was a misrepresentation by the insured. And in that case, the policy was rescinded. And the court said, in effect, the insurance policy considered never to have existed. That's the same argument that Jones makes in this case. But the court said that only applied to the party making the misrepresentation. And it said it's a question of equity, whether an innocent third party could still proceed on the rescinded contract. And since that time, I think there's been at least 4 published Court of Appeals cases where the courts held that they would balance the equities to say, can this innocent third party recover on a rescinded policy? Now, Bazzi isn't as strong for my argument as our case is, because our case, we have the Supreme Court saying in the foremost insurance case and the Citibank case that there's 2 policies. There's one between the insurance company and insured, and one between the insurance company and the mortgage holder. And in this case, we didn't rescind the policy with the mortgage holder. We followed that policy and paid them entirely off and then become subrogated. And in the that Hartford accident case and the insurance case, those cases said that equitable subrogation is a legal fiction through which a person who pays a debt for which another is primarily responsible is substituted or subrogated to all the rights and remedies of the other. And in insurance, that opinion states, in addition to that, equitable subrogation is the mode which equity adapts to compel the ultimate payment of a debt by one who in justice, equity, and good conscience ought to pay it. And as applied to this case, between Meemic and Jones, according to justice, equity, and good conscience, the mortgage must be paid by Jones, because what are the equities? Jones makes multiple misrepresentations in her policies that she lives there. It's her primary residence. She has no other place to live. She was going to continue living there during the policy. Signed the application. That was all true and correct. Meemic relied on that and issued the policy, even though those statements were all false. She obtained the property from Habitat for Humanity, which is a charity which provides homes for qualified people. And it's not for you to get a house to rent. And she violated her contract with a mortgage with Habitat for Humanity for renting it. And she's also trying to sell it. She violated her contract with Habitat for Humanity and mortgage by trying to sell it. And as far as Meemic goes, we issued the policy based on the application. She admitted she made misrepresentation when she made the claim. According to the policy, Meemic voided the policy. Meemic refunded her entire premium with interest, and Meemic fully paid the mortgage holder. So Meemic complied on all equitable grounds, and Jones didn't comply with any. Under insurance and the Hartford accident case, the person who should pay under justice and equity, regardless of what the contract says, is Jones. So if the court has any questions, I'd be happy to answer any of the questions you have.
Thank you, Mr. Schmidt. Are there additional questions for Mr. Schmidt? You may reserve those 50 seconds for rebuttal if you'd like.
Thank you.
Okay, Ms. Davis.
Good morning. First of all, I'd like to point out that the complaint that was filed in this case and that is attached to my brief in opposition to application for leave to appeal is based solely upon the policy language. There's nothing in there, no claim for equitable subrogation. Paragraph 36 states, pursuant to the above cited condition of the policy, Meemic is entitled to be subrogated to the extent of its payments. There is absolutely nothing in the complaint about equitable subrogation. It was not raised below, it was not argued below, and it was not discussed. I think the equitable subrogation argument cannot be considered by this honorable court. The question is whether or not denial is the same as declaring a policy void ab initio in these circumstances. The answer is absolutely not. In the Court of Appeals case, in this case, the court said there's a difference, and the insurance company is bound by the language of the policy, which it wrote. In a more recent case, a published decision of the Michigan Court of Appeals, VHS versus State Farm, which is 2021 Westlaw 1236120, approved for publication on May 20th of 2021. The court was distinguishing certain cases under the no-fault context and said, this case is factually distinguishable from Haydaw, Meemic, and Williams, where the insurers sought to rescind or void the subject insurance policies on the basis of allegations of fraud on the part of the insured. Here, in the VHS case, defendant has not sought to rescind its policy, rather it is seeking to plead fraud with particularity in order to justify denial of the claimed benefits. The insurance company in this case had the option to rescind the policy. It certainly had the right to do so, or deny the policy. But once it rescinded the policy, it doesn't exist. And Meemic elected to sever its contractual relationship with Ms. Jones and therefore cannot rely upon a policy provision in a contract which is rescinded. There's no contractual relationship which obligates Ms. Jones to pay the insurance company for the money that it paid. And I also like to point out that there's no evidence that it was fully paid. I know they paid $53,000. I don't have any evidence that it was fully paid, which is another one of the elements of equitable subrogation, which should not be part of this case.
Davis, let me interrupt you and see what questions my colleagues have. And
Thank you.
We can get back. Yeah. Justice Viviano.
No questions. Thank you.
Justice Bernstein.
No questions at this time. Thank you.
Justice Clement.
Just to clarify where you started. So can Meemic go back and amend their complaint on the equitable subrogation?
I don't know. I think it's probably a little late for them to do that. They never asked to do that. If they had a claim for equitable subrogation, they should have brought it with the complaint or asking to amend their complaint, and they didn't do any of that below.
But it was denied under C10. I'm just trying to think this through. It was denied under C10 and MCR 2.116I5 gives them the opportunity to amend, and it was remanded. Court of Appeals remanded it, right? So they could still amend.
Correct. And when they remanded it, they didn't move to amend the complaint.
Well, they brought it here. So it's still on.
They appealed to the Court of Appeals. The Court of Appeals ruled in favor of the insured. It went back to, and at that point, they brought it to this court.
Okay, thank you.
Justice Cavanagh.
So tell me if I'm reading or have an understanding of the court, if my reading comports with yours. If the Court of Appeals analysis of why Meemic was not entitled to subrogation hinged on their conclusion that the claim wasn't denied, and the policy requires it to be denied, that they've paid city mortgage and that they've denied the claim. If we disagree factually that or we conclude that based on the factual record where the letter cited a claim number, it rescinded the policy and also said, therefore, the claim is denied. If we disagree with the Court of Appeals that they didn't satisfy that first step, does the rest of their analysis fall away because they're regarding subrogation, because it was based on perhaps the factually faulty conclusion that the claim wasn't denied?
No. And
Okay,
the reason
tell me
being-
tell me why you would win even if we conclude that the claim was denied.
If the claim was denied and they still rescinded it, declared the policy void ab initio, you have two contracts. You have the contract with the insured, you have the contract with the mortgagee. In this case, they elected to rescind the policy. So even if they denied it, they also rescinded it, which is a far more robust decision. And they're stuck with their decision to rescind the policy with Ms. Jones. And once they rescind the policy with Ms. Jones, the denial really doesn't matter because you have a rescinded policy that was declared void ab initio, and you cannot rely upon those the requirements of a policy which they have elected to say never existed since 2014. There can be no.
Ms. Davis, I understand, and I think
Right.
I understand that is an argument, and you may be correct. I think there's an argument on the other side that despite that, and some courts have come down on two different ways on this. Some courts had said despite the fact that the policy was voided, there is still a subrogation action, and some say no, once the policy's gone, you don't have a policy. The right to subrogate is vanished with the contract, right?
Right.
But the Court of Appeals didn't decide that, right? Because it stopped, it said there was no denial, and therefore we don't have to really sort of grapple with that. If we disagree that it was denied, wouldn't then that argument of which one's right about whether that subrogation right survives, that still has yet to be decided by the Court of Appeals.
Right. But if they merely denied the claim, perhaps he would be entitled to subrogation, the insurance company. But here they did not merely deny the claim. They got rid of the entire policy. It never existed. By doing that, basic contract law, basic insurance law in Michigan states that if you do that, you can't rely on those rights. And I think that whether or not there was a denial doesn't matter if you want to say that they denied the claim. Maybe they did deny the claim, but they also rescinded the policy. And by rescinding the policy or the contractual relationship between Ms. Jones and the insurance company, you can't then go say, well, but we're going to rely on these contractual rights anyways. Because there's no contract. She's not obligated under any contract. They elected to sever their relationship with her.
Okay. All right. Thank you very much.
Any other questions? I think
my argument. Hang on. A couple justices haven't had a chance yet. Justice Welch. I don't think Justice.
I have no questions.
Justice Zahra.
Thank you. Is it your position that once the policy was rescinded, that the insurer had no obligation to pay the mortgagee?
No, they had an obligation to pay the mortgagee.
Okay.
That's what the policy says. They had the obligation to pay
So
because there's two
policy
contracts.
exists, that's the mortgagee.
Because the courts have held that there are two contracts.
That's fine. That's fine. I'm good with that. This is just a premise.
Okay.
So what do
Okay,
we make of the policy language that says we will be subrogated to the extent of our payment to all the rights that the mortgagee has under the mortgage on the property, or at our option we may pay the mortgagee the whole principal on the mortgage and any interest due. In this event, we may receive a full assignment and transfer of the mortgage and all securities held by the collateral for the mortgage debt. It seems to me that they have everything they need at that point to pursue your client.
Well, first of all, there's been no assignment of the mortgage debt that I've ever seen. That's never been presented either below or on the appellate level. Second of all, that language goes to the insured. We are going to be subrogated and all that, but if the insured is no longer part to the contract, then there's no obligation on her part.
It's under the provision of the contract that says rights and duties of mortgagee. It makes no reference to the insured. The mortgagee has a right to collect, to be paid, but they're reserving in that instance the right to be subrogated for that.
The mortgagee has a right to be paid. Who they can subrogate against the person who they believe caused the fire or whatever, but the mortgagee, I just don't see how that even exists anymore. They can pay the mortgagee. They wrote the contract. They could have denied the claim. They didn't, merely deny the claim. And it's a basic contractual argument, and they can't rely on those rights.
And what's the legal reason for that?
The legal reason for that is there's no contractual relationship. There's no contract between the insured and the insurer as a result of Meemic's decision to rescind the policy.
But they're seeking the rights held by the mortgagee. When they pay the mortgagee, they want the mortgagee's rights. Are they not entitled to that?
Not once they rescinded the policy.
So this portion of the language is meaningless.
No, it's not meaningless. Of course, it has meaning. But I think it's been rescinded. They can't go after someone with whom they no longer have a contractual relationship. If you're talking about going after a third party, perhaps they do. The insurance company could go after, the whatever it was that caused the fire, but they can't go after the insured.
Well, the second clause says if we pay the mortgagee for any loss and deny payment to you, you being the insured. Does that, when they use the term deny payment, are they saying deny the claim in the legal sense?
I would agree. I would think so.
Okay. I have no more questions. Thanks.
Ms. Davis, I want to go back to Justice Kavanagh's question, because I think I heard you give a couple different answers. I just want to understand what your answer is. It seems to me that, I think it seems to Justice Cavanagh, that the Court of Appeals analysis hinged on this idea that because the policy was rescinded, it was not denied, but that's just not what the record shows. The record shows that it was, the claim was denied, and the rescission of the policy sort of explained why the claim was denied. I think the letter said, that Meemic said, we're rescinding the policy and therefore your claim is denied. And given that that's sort of a fundamental flaw, I mean, I don't disagree with the Court of Appeals definitions of rescind versus deny. Obviously they're different, and but given that they held that the entire reason there was no subrogation was because it was not denied, and that's just factually not true. Shouldn't we let them
saying, excuse me.
Go ahead. No, go ahead.
No, I think they're saying that the denial portion, once you rescind it, they can deny it, they can accept it, they can do whatever they want, because there's nothing to do anymore once they rescind the policy and declare it void ab initio. I think that's what the Court of Appeals was.
You think that's what they meant? It's not what they said, but you think it's what they meant. I see.
I do.
Okay. You have 29 seconds left. Go ahead.
Thank you. I have nothing more to add. I do want to say that many of these cases deal with the mandates of the No Fault Act, and we're not covered by the No Fault Act here. We're covered by MCL 500.2833, which is the fire insurance contract, which has not been addressed in these rescission cases by this court or the Court of Appeals for the most part.
Thank you. Mr. Schmidt, you have some rebuttal time.
Thank
52
you.
seconds.
There's not a single case, appellate case, that we found that holds what the Court of Appeals held or what Jones is arguing. Every case says when you rescind with a standard mortgage clause, you can still subrogate. That's what Citizen State Bank said. That's what every case that's dealt with this throughout the country. Number two, this situation puts Meemic and every insurer in an impossible situation. So any insurer that is forced to cover a risk they didn't assume. So you have an insurance company submits an application, the person lies on it, they issue the policy. If a loss occurs and the insurer does not rescind, then they've got to pay on a loss they didn't agree to cover. If they do rescind, according to this decision, they can't subrogate against the insured. That's a no way proposition that could never be the intent of the parties, and no court has ever ruled you can do that. So it's in an impossible position.
Thank you, counsel. Thank you both. The case will be submitted.
Thank you very much.